This is part 6 of contracts, beginning with statute of frauds. Contracts that fall within the statute of frauds are unenforceable unless they're evidenced by a writing. The writing must be signed and contain all essential terms of the deal. Contracts that fall within the statute of frauds include, in the context of marriage, the prenuptial agreement, but not the marriage contract. In suitorship, which is a contract to answer for the debt of another. A contract also within the statute of frauds is a contract that cannot be performed within a year. Here, however, the actual terms of the contract must make it impossible. Contracts under the UCC that fall within the statute of frauds are contracts for sale of goods greater than $500. Again, must be evidenced by a writing, include parties. Under the UCC, it must include a quantity, and the writing must be signed. In regards to the statute of frauds and real estate transactions, this statute of frauds includes a contract providing for the conveyance, so that falls within the statute of frauds, but not the conveyance itself. Again, in the statute of frauds, contracts that fall under the statute of frauds are unenforceable unless evidenced by a writing, signed. They contain all essential terms of the deal. Now, the writing need not be formal. Elements need not be in one writing. It may be in more than one writing if one writing references all others, such as an appendix and or a list of forms. It's okay if the writing is lost or destroyed. Existence of the contract can be proven by oral evidence, or existence of the writing can be proven by oral evidence. Contracts that fall under an exception to the statute of frauds writing requirement, where a writing is not required. This is specially manufactured goods. No writing is required if the goods are to be specially manufactured for the buyer. They're not suitable for sale to others, and the seller has made either a substantial beginning of the manufacture or commitments for their procurement. Also, contract for partial payment. When the part of the purchase price for a single item has been paid, the contract is enforced, and the partial payment falls outside of the UCC statute of frauds, only to the extent of the purchase. Receipt and acceptance. Here the contract is outside the UCC statute of frauds to the extent that the goods are received and accepted. Makes sense. Here you've received them and you've accepted them. That's forming a contract. Where both parties are merchant, also an exception to the statute of frauds writing requirement. Both parties are merchant. And a merchant fails to respond to a memorandum. The receiving party has reason to know its contents, and the receiving party does not object in writing to the memorandum within 10 days. Then the contract is enforceable against the receiving party, even though he has not signed it. In regards to modifications of a contract in the statute of frauds, under the UCC, the statute of frauds applies to modifications bringing the contract within the statute of frauds, or if the contract specifically states modifications must be in writing. Under the common law, provisions requiring modification to be in writing, regardless of the statute of frauds, are not enforceable. Moving on to the parole evidence rule. The parole evidence rule prevents parties to a written contract from presenting prior extrinsic evidence. There's evidence of negotiation, conversations, and communications that contradict the contract terms as written. Parole evidence applies to integration. Now, this is where the agreement is integrated. The parole evidence rule applies, and it's integrated. The agreement is integrated if it is the final agreement, not a draft or preliminary negotiation document. You have total integration and partial integration. Total integration is where the contract or the written agreement expresses all contract terms. Then, where there's total integration, there's no extrinsic evidence allowed. Partial integration is where you have some but not all terms of the contract are included in the agreement. Here, extrinsic evidence is allowed, but that extrinsic evidence must not contradict the terms in the contract. Now, how do you tell whether it is total integration or partial integration? You have to look at the intent of the parties. The intent of the parties determines the degree of integration. Under the common law, the court looks to the four corners of the document. This is the four corners rule. To determine intent of the parties and therefore degree of integration, the court only looks to the writing itself. If there's a merger clause in the writing, where all prior agreements merge into that one, or if the contract is sufficiently detailed, then the court will consider the writing totally integrated. Now, under the second restatement, if circumstances indicate that a term would naturally be omitted, and it's omitted, then it can be introduced if it does not contradict the writing. Under the UCC, which is the most lenient, and we've seen that throughout our discussion, there's a presumption of partial integration. This lets in any outside terms. The court here applies a course of performance, course of dealing, and trade usage. Course of performance is conduct relevant to understanding an agreement, or relevant to waiver or modification of the agreement. Course of dealing is conduct in prior transaction. Trade usage is practice and or method of dealing specific to an industry. Looking at where parole evidence rule is inapplicable. Parole evidence rule is not applicable to communications after execution of the written contract. This only applies to agreements before or contemporaneously with execution of the written contract. Parole evidence is also inapplicable, or the parole evidence rule is also inapplicable to defenses such as raising an excuse, which is a mistake or misrepresentation, establishing a defense such as incompetence, illegality, duress, lack of consideration. Parole evidence is inapplicable to establishing a condition precedent. Parole evidence is also inapplicable where there is ambiguity in the contract and there is an interpretation of the term is required. Here, the majority of jurisdictions go to the plain meaning of the word. The minority of jurisdictions look at the context of the word in the writing. And that completes part 6 of contracts.